The personal views expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a very special guest all the way from New Zealand, Liz MacPherson. She is the Deputy Privacy Commissioner at the Office of the Privacy Commissioner of New Zealand. Welcome.
It's fantastic to be here, Debbie.
Well, we're connected on LinkedIn, and I saw your name pop up, and I was like, "Oh my gosh, I'd love to have Liz on the show." And so I was so excited when you agreed to be on the show. It took us a while to get this together, but I'm really happy to have you here.
Oh, well, thank you so much. It's a real privilege, and I follow you, obviously, and just really find the insights that come from your podcast so valuable. So thank you.
Oh, that's so sweet. Thank you so much. Well, I would just love to hear. I would love for you to tell the audience your trajectory in privacy, how you got to where you are, and what you're seeing in privacy in New Zealand and beyond.
Okay, well, like a lot of people who come to privacy, I've come to it by sort of bit of a wayward journey. But when I look back at it, everything was connected. So I have been working in and around the public sector in New Zealand for quite some time now, longer than I care to admit. And so I've worked in the public sector in roles, policy roles, governance roles, in the economic space, at the labour market space, and then moved through into leadership roles in those areas at our Ministry for Business and Innovation and Employment. I was at the Department of Labour, leading part of that for some time. And then from there, I moved and became the government statistician of New Zealand. So that's the equivalent of the chief statistician for the US. And so in that role, I was responsible for all of the data and statistics, national data and statistics that's provided for New Zealand, an independent role around the production of those data and statistics. And in that role, very focused on the power of data, the fact that information can unlock so much for individuals, for society as a whole, in terms of well-being, opportunities, managing risks, and a variety of other things. And one of the things that a statistics organisation holds very dear is the integrity of the information, but also the protection of that information. So a lot of focus put on ensuring confidentiality, which is not the same as privacy, but very closely related. We always took huge amounts of care to make sure that individuals weren't identifiable information that was provided. And while I was government statistician, I started working with the Office of the Privacy Commissioner at the time, John Edwards, around some principles for safe and effective use of data and ensuring that it stayed safe while you're undertaking analysis, including thinking about algorithm use, because the role of the government statistician had expanded to not only being about the statistical information, but also I became the government's chief data steward. So I was responsible for thinking about how we were using, but also keeping safe data across the government sector. Upon leaving the role as the government statistician, John Edwards, the Privacy Commissioner, asked me if I would come in and do some work with them for a while. And I intended it to only be a year. But here I am, almost 6 years later. And I'd have to say that working in privacy has become a real passion for me. I can see the critical importance, as I could when I was government statistician, but even more now, of personal information. The fact that we're not just talking about data, we're talking about people. We're talking about their lives, and we're talking about information that can unlock doors for them, but also can close doors too if the wrong person gets a hold of it. So every day I come to work and there's proactive work that we're doing, but there's also the reactive work that we do to help individuals who have complaints, help them find resolution, but also to focus on compliance action where there's been a data breach, as we just had over our holiday period. But it's a real privilege to work here. Sometimes it feels a bit dystopian when you look at the types of issues that we confront every day on behalf of New Zealanders. But for me, it's incredibly rewarding to be able to do something about this based here at this organisation. So yeah, that's me.
Wow, that's a really interesting segue into privacy. And so I guess when you talked about being a statistician, I think automatically about differential privacy.
Mm.
And sometimes people, because they don't understand that, they don't know why differential privacy, why it works in things like statistics and maybe not in other things, in other parts of privacy. So I think that's really interesting. But one of the things that you said was about, which I think is very key, and the data uses really are about safe and effective uses of data. So regardless of what else people say it is, at the base, I think that's what it is.
I agree entirely. And one of the conversations we have quite regularly here in New Zealand, I'm sure it's happening globally, I know it's happening globally, is we have been in a world for some time and increasingly in a world where jurisdictions, governments, businesses, individuals themselves want to use personal information, data to unlock, innovations, to be able to do things that we haven't been able to do before faster, more efficiently, to be able to solve problems that we've had. And often you have this conversation which goes along the lines of, I could have done this but for the Privacy Act or but for the privacy restrictions, or that somehow our focus on keeping information safe is holding everybody back. I guess from our perspective, guardrails are critical to actually being able to innovate safely and with speed. So there's often the conversation which is about the fact that the thing that helps a car go faster, and the innovation that helped a car go faster was brakes. Brakes and good tires. Without brakes and good tires, you couldn't have fast cars. So in the same way, the way we look at it is that in order for you to be able to innovate, to achieve all the things that we want to achieve as countries, as individuals, as businesses, you actually need good guardrails, and privacy is a critical part of that.
I'm smiling because the analogy that you used about cars and brakes was exactly the same thing that was on my mind. It's so
Yeah,
true.
it's so true. If it wasn't for brakes, we'd still be wandering around with red flags in front of cars, and the cars would only be able to go 4 miles an hour. So,
It's so true. So true. Well, I want to talk a little bit about foodstuffs in supermarkets. I
mm,
know that there have been cases that have come up, not just in New Zealand, but in other countries, including the US. This
mhm,
is actually, I hadn't really thought about the connection here, but because companies that sell food, like supermarkets, first of all, they have a lot of interaction with the public. They have a lot of data about the public and how they use
mhm.
tools. They seem to be rapidly going forward into biometrics and other things that I think sometimes these organizations, they may think that they're cool
Yep.
things. They may be cool, but they may not be thinking about the ramifications of it in terms of how they collect and retain that data. But I want your thoughts there.
Well, maybe if I just tell your listeners a little bit about what happened here. So, Foodstuffs is one of two major supermarket grocery chains in New Zealand. And the one that we were working with was Foodstuffs North Island. We have two major islands in New Zealand, North Island and the South Island, of names. And Foodstuffs at North Island had been having some issues with respect to retail crime. And They had tried a variety of other tools. So they'd had security guards for some time, they'd had CCTV cameras for some time, and a variety of other things that you'd look at, locking cabinets, locking trolleys, locking number of things. And this hadn't really worked for them. They discovered that some of their supermarket, it's a franchisee type model. So each supermarket, they belong to the sort of cooperative, but each supermarket is owned by the franchise owner. And they discovered that a group of those supermarkets had gone ahead and put in place facial recognition without actually really thinking about it particularly. They just thought it could be a good idea, and so they had put it in place. When it was discovered this was happening, they came and saw us and said, look, actually, we want to make sure we're doing this right. So we want to work with you on how we could do this in a privacy enhancing way. So we said, first of all, stop everybody who's currently using it while you work this one through. So over a period of time, they worked with us. I think probably I'll just let the listeners know that in New Zealand, there is very little use, at that point in time in particular, very little use of facial recognition in New Zealand at all, beyond obviously people's mobile phones and things like that. But in terms of businesses, there wasn't really any use of facial recognition technology. We have some at the border, obviously, in terms of people going across our borders. But apart from those sorts of uses, in one particular case in gambling venues for problem gamblers, covered by its own legislation, there wasn't facial recognition. So for us, this was a first use of facial recognition in this way, and the fact that it was taking place in an essential service industry made a difference. So they worked with us on their privacy impact statement. So they worked through a privacy impact analysis. We basically were a sounding board for them, and as they worked through that. And I think the other thing that your listeners need to know about the privacy framework in New Zealand is that we have one act, the Privacy Act 2020, that governs all organisations pretty much that collect personal information in New Zealand. The key thing that your listeners need to understand is that unlike a lot of other privacy laws globally, ours is not consent-based. It's not based on consent. It's based on purpose and context. So you have to have a lawful purpose collected with your organisation to collect the information, and it has to be necessary for that purpose. And also, context matters in terms of the sensitivity information as well. So we worked all of that through with them, and they were able to put in place a variety of mitigations against the privacy risks that were identified, including things like immediate deletion of all unsuccessful matches as somebody came through the door of a supermarket, against a watch list of persons of interest who had shoplifted before or had been violent before, particularly a focus on violence and an assault. But they weren't able to give us a critical piece of information or prove a particular issue which is connected with that purpose and necessity for the purpose, which was, is this actually going to be effective in reducing violent crime at all? So for us, when we step through from purpose, particularly with biometrics, because we now have a new biometrics privacy code in place, we ask the question, is it necessary for that purpose, and is it proportionate? And so effectiveness is a critical part of that. So they didn't have the evidence to prove this because they couldn't get any, because they hadn't used it. And there wasn't really the evidence that they could provide us from similar situations overseas that demonstrated that it really made a difference. So it was a bit of a catch-22 situation, and the way we worked our way through this was to propose a trial. So the supermarket established a trial with an independent evaluator associated with the trial that took place in 25 of their stores. And the evaluation was set up to determine whether the use of facial recognition was effective in reducing the incidence of particularly violent crime. But at the same time, Foodstuffs also used the evaluation as a way for them to learn as they went through the trial period in terms of whether the mitigations they'd put in place against privacy risk actually worked or not. So a bit of an innovative way of approaching this. Was the first time we've ever had a trial running under the Privacy Act. And to ensure that we were keeping everybody safe while we did this, we established an inquiry under the Privacy Act to run alongside the trial. And the inquiry allowed us to basically monitor the trial as it went along. And essentially the message we were giving to people was, you have to basically meet the basic requirements of the Privacy Act when you're doing this trial. The only thing you should be testing is effectiveness. All your other safeguards should already be in place. And so part of what we were walking alongside was to make sure that we had shop visits during the time to check their security arrangements, to have a look at their training, to test things as we went along. At the end of that period of time, we came to the conclusion that on balance, given the mitigations that they'd put in place, that this was an acceptable use under the Privacy Act in this particular context for this particular supermarket and the way they'd done it. And I think there were a number of things that we learnt through that we've built into some information for the sector as a whole, sitting under our new biometrics privacy code, which we can talk about in a bit. So I think that one of the key things was we have people who think that you can just pick up an FRT camera, plug it into your system, and hey presto, everything is fine. The fact is that this is not a plug and play type situation. Facial recognition, you're talking about biometric information, which is some of the most sensitive information a person can have. You can change your password, you can't change your face, you can't change other characteristics that are you. It's not about you, it actually is you in this case. So you have to be very, very careful about this. You have to be sure that there isn't anything else that you could do that would achieve the same purpose at a lower privacy risk. And you have to have thought that through. So I guess the key things are careful thought before deployment is absolutely critical. The quality of that list I talked about earlier is just, I can't stress how important it is. The data quality to start off with. So are your images good quality images? They're actually accurate. How people get on and off the list. So how do people get on? What criteria do you use for putting somebody on a list? Is it because you've got evidence of a serious assault, for example? Is that how they get on a list? Are they put on because they're trespassed? What's the evidence for how they get trespassed? Who says they get on? How can they get on? How do they know that they're on the list? How long do they stay on the list? And then one of the things we've discovered over time is access controls in terms of who within your organisation gets to see this information is also really important. Something else that, as I said, goes back to the plug and play thing, facial recognition needs to be part of a wider operating system. Which includes your people in your organisation, your employees. So have you trained them as to how to use this? How does the rest of your system operate? Where do you store things? How do you store things? What is the quality of the facial recognition system you've purchased? What's the quality of cameras? Quality of where they're placed? We had someone the other day, one of the things that came out of the trial was where you've put your camera and the time of day and the quality of the camera makes such a difference to the accuracy, which of course is vitally important. Some other things, telling your customers about the fact that you're using facial recognition is critical. So they need to know before they come in the store that it's being used. And they need to know how they would go about getting access to that information for correction purposes. So, for example, I have been in a store, and the next time I come into the store, I'm told that I'm not allowed in the store because there was some issue. I need to be able to challenge that. I need to be able to say, well, how did I get on the list? Where's the evidence about how I got on the list? And we did have one situation during the trial where a Māori woman was accused of being someone she wasn't, doing things that she hadn't done. Fortunately, there weren't more of those sorts of cases, but for foodstuffs, what that said to them was the training is critically important. The people who were operating at that time weren't the people who were fully trained. They weren't in store. The human in the loop is critical. And if you know that facial recognition, because it is, after all, just a camera that works with light and dark, is not as accurate for people with darker skins, then you need to put steps in place to make sure that you're actually mitigating against that. So there were a whole range of things that we learnt through that we've published. And I guess the last thing I'd basically say is that there's no set and forget here. You know, you have to review and monitor your systems on an ongoing basis. You don't just set them up and think they're fine. You actually have to look across the whole systems, their security, how many false positives and false negatives you've been getting, and keep reviewing the effectiveness of the system as you go. So yeah, I've been babbling on, Deb.
No, this is an incredible case study because I think a lot of people think that they're going to do something wrong and then the regulator is going to come to them and then maybe this process will start. But the fact that foodstuffs came to you proactively and said, we want to do this and we want to do this in the right way, I think that's an excellent example. And then you've learned so much that you can help other people fully understand it from different angles.
Yeah, is so useful. We've got a number, so sort of backing up a bit. At the same time as we were working with foodstuffs, we were also developing a biometric processing privacy code for New Zealand. And again, for your listeners, the New Zealand Privacy Act is an interesting one in that it includes a quite extraordinary power, I think, which is that the Privacy Commissioner has the power to establish privacy information codes which actually modify the Act. And once they've been promulgated, they become law. So we can effectively, after we've gone through the statutory processes that are required, which include a lot of consultation, we can put in place a code which effectively changes our law. It modifies 13 privacy principles, which are the heart of our. So in the case of biometric, back in 2021, we were really concerned that we could see biometrics become the future of biometrics was that people were going to want to use it more and more and more for a variety of different things. And we could see it becoming commodified. So you effectively, sooner or later it will be you get a camera and you get biometrics with it, sort of like, would you like a side of biometrics with your whatever? And because we could see that coming, we decided we needed to strengthen our legislation by looking at the biometrics area. And the reason we wanted to do this was because our act, again, unlike some other acts, because it's really focused on purpose and context. So it would essentially say to you, for example, the more sensitive the information you're collecting, the more robust your safeguards have to be, the clearer you have to be about necessity for collecting this information, et cetera, et cetera. So we don't have, for that reason, we don't actually have sensitive information defined in our Act, like some other jurisdictions. So from other jurisdictions. So we decided we needed to strengthen our Act. So we put in place the Biometric Processing Privacy Code after position papers and 4 streams of consultation, and it was promulgated in November last year, and came into effect then for pretty close to then for new uses of biometric, and comes into effect in August of this year for existing uses of biometrics, to give people a bit of time to get their ducks in a row. The key thing about the biometrics code is it strengthens and clarifies the requirements to assess remember I was talking about effectiveness before? To assess effectiveness and proportionality, to adopt safeguards to reduce privacy risk, and to tell people that a biometric system is in use before collecting. The other thing it does is it limits some particularly intrusive uses of biometrics. So when we talk about biometrics, biometric processing code, it regulates organisations that collect, hold, and use physical or behavioural characteristics of a person. That's what we define as being biometric information for the purposes of biometric processing. And there are 3 things that we talk about there. So biometric processing, we say, is using biometric information for verification. So that's one-to-one. I am who I say I am. For identification, so that's one-to-many. So I want to identify this person within a collection of people, for example. Or categorization. And that's what we talk about when we're talking about categorization, is essentially using an automated process, using biometric information to collect, infer, or detect certain types, or generate certain types of information, or to categorize somebody. So, for example, trying to infer somebody's personality or emotions or mental state. So that's what falls into the categorization space. Trying to determine somebody's health information by they walk past, and there are systems that can infer from the way that you're walking some medical conditions, those sorts of things. We've put some limits on when you can use biometric categorization. And so we've effectively said that if you're we've got another code, the Health Information Privacy Code, and if you're covered by that, then you follow the health direction in that. But if you're a business that isn't a health agency, then you can use categorization for health and safety reasons. So, for example, there are some businesses that use cameras and other things to detect fatigue for people for whom fatigue would actually be a health and safety risk. So, for example, you can imagine somebody like my brother, actually, his job is to drive these huge tankers. If you get tired and fall asleep at the wheel, that's not only a risk to you, but a risk to everybody else on the road. So being able to use that sort of technology for fatigue detection is something that we've said is okay. So we've put this biometric code in place. And one of the things it does critically, and the foodstuffs trial helped us with this in terms of just strengthening our thinking, is it effectively says there's a threshold you have to get over before you can use biometrics. And that threshold is that you have to basically have been able to prove that if we came and looked, that your use of biometrics is connected to your purpose, that you have gone through the process of assessing effectiveness to prove necessity, and you've also looked at proportionality, i.e., there is nothing else that you could have used reasonably that could have achieved the same purpose with the same level of effectiveness or similar level of effectiveness. And you also need to have assessed, when you're doing that proportionality assessment, you need to be basically balancing the risk against the benefits, basically. And learning from the foodstuffs work, what we built into the code was the ability for people to do a trial.
Oh, that's incredible. I want to talk a little bit about categorization. Now, this fascinates me because I think that you've addressed it very well. because this
Mm-hmm.
is the issue that concerns me a lot, and that is
Yep.
inference. It's part of that, as you well know, I'm sure, is about what action does the company take as a result of that conversation. What are your thoughts?
Well, I mean, essentially, we've said that in New Zealand we have a Human Rights Act, and there are certain things that are an absolute no-no under our Human Rights Act. So that is making calls about people because of things you infer about their age or their gender or their sex or a variety of other things. So we haven't said no biometric categorization but for the very reason you've discussed. We've said you can only use this where it is about pretty much health and safety. So we've said age detection potentially, if it's accurate, for if you need to effectively restrict people's access to things because of age. But even there, you have to be very careful. But yes, I mean, the critical thing here is, what are you using this for? It has to go back to a lawful purpose again. And so we have quite definitely said there's placed fair use limits on attempting to infer people's emotions, attempting to infer their sexual orientation, and attempting to infer and their health status from the facial recognition or biometrics generally.
I want your thoughts about, and this goes with purpose limitation as well, and that's
Mm.
the data retention. And
Mm-hmm.
so I feel like this is an area where companies get into some of the most trouble because a lot of times they retain data entirely too long and it creates more risk for them as an organization, but then also for individuals. But I want your thoughts on data retention.
Oh, absolutely. I am on record as describing retention as the sleeping giant of cybersecurity. I really believe it is a critical issue. And if you look at some of the big data breaches around the world, in Australia, here and other places, very often when you get a huge data breach, a lot of the information shouldn't even actually have been held. You know, huge risk to the organization, huge risk to the individuals who potentially didn't even know the data was still there. So from our perspective, yes, retention is critical, and the way we think about it is, again, you can only keep data for as long as your purpose allows you to, unless there's another law potentially that requires you to keep it. Like, for example, our tax laws require certain types of information to be kept for 7 years or something like that. So, but if you no longer have the purpose for which you collected the information, that information should be being deleted. And our advice to businesses, to anyone who collects information, is once you've collected it, you have to protect it. You collect it, you protect it. So, first thing you actually have to ask yourselves is, do I need to collect it at all? No, for my purpose. Do I really need to be collecting this sensitive information or personal information? Because once I do, I've got to protect it. And I've got to, part of protecting it is having, as it comes in the door, I should actually have a retention policy for it. Yeah. Which essentially says after it ages out to this point, I delete it. The person's no longer my customer after a certain period of time, I delete it. That's absolutely critical, and so many businesses just forget about it. Uh, and we've had situations where I can remember one which was associated with a recreation facility that not only collected information it didn't need, essentially their charging rate said that somebody who was local got charged less than somebody who was a visitor, right? So they wanted people to prove that they were local. So what did they do? Instead of just asking to see something, they actually took photographs of it, and then they stored, driver's licenses and other identifying information in their system, which they didn't need. And then they forgot that they had it when they moved to another system, and then their legacy system got hacked with all of that identifying information in it. So these basic hygiene matters are critical. Ultimately, it goes to the trust and confidence that the people who use your services have in you. And that should be an organization's bottom line, putting those people first.
It's so true. And I
Mm.
think over time, people leave companies, they make changes to their technology, but their responsibility for that data remains the same. And so sometimes I think people forget that part of it and it becomes a challenge.
Yeah, we've put together some guidance, which all of the stuff I've been talking about to you about is on our website, by the way, privacy.org.nz. But we put together some guidance, which we call the How to Do Privacy Well. And it takes you right the way through the life cycle of the information. And what we really suggest to people is they put together what we describe as a privacy management plan. And it has all of these aspects in it. And you keep that plan up to date. And ultimately, it goes to treating that personal data, that personal information that you hold, as carefully as you would anything that is commercially sensitive, as carefully as that, or more carefully than that. But if we're trying to talk to people in the C-suite, this is critical to your ability to not only, potentially innovate in order to give your customers better services, but the trust and confidence that your customers have in you. Time and time again, we see surveys where, of the public, where people say, you know, if I know that a firm has been hacked and they didn't have the right, safeguards in place, and they had a big data breach, I'm going to think about moving. You know, I don't want to do business with somebody who doesn't take care of my personal information, because ultimately that tells me something about who they care about, whether they actually really do put their customers first. So we would say to people, all of those elements of the information life cycle in terms of a person's information that you're collecting are important. They're basic hygiene, but also, and critically importantly, you should be thinking about this as an asset or that you are protecting.
Absolutely. I like to say, I tell organizations that they need to think of the human as
Mhm.
stakeholder, as if they were a person on the board, right? So their data is also important, not just because you sell them a product or service, but because you're holding information about them.
I couldn't agree more. Here in New Zealand, so people who've travelled here will know that our Indigenous culture, the Maori culture, is critically important to the way we think about things in here in New Zealand. And from a Te Ao Māori perspective, there is a real focus on the person. So there's a saying, he tangata, like the people. And our advice always to an organisation, for example, who's suffered a data breach, is that if you put the person at the centre of your response, you'll very seldom go wrong. So, really think about that person, and if the person and, treating their information as a taonga, their data, taonga means treasure in Māori. If you treat it like a treasure, that will actually take you in the right direction.
I agree with that completely. Well,
Mm.
Liz, if it were the world according to you and we did everything you said, what would be your wish for privacy or data protection anywhere in the world, whether that be technology, human behavior, or regulation?
Well, I think we come back to what we've just said. I think we need to have reinforcing systems of incentives, penalties, and education that reinforce the importance of treating personal information as a treasure, as a taonga. Whether we're talking about AI, biometrics, basic personal information, it's about having those systems in place that mean that anyone who has the privilege to look after somebody else's personal information is taking it seriously.
Wow, this has been incredible. Well,
Mhm.
thank you so much for being on the show. Your insights are incredible, and people, please definitely check out the website. We are all looking very closely and admiring all the work that you're doing in New Zealand. It's very instructive for all of us around the world to see how creative and pragmatic the way that you've been about this. And I think ultimately that's the way it should be. So it should be a surprise to companies. It's like, okay, this is part and parcel of your
Mhm.
responsibility, and this is the way the regulators can help you get there.
Yeah. No, I think we need to think about ourselves as a privacy ecosystem. We all work together to achieve the outcomes that we're after. So thank you so much. It's been just a delight to have a chat with you, Dewey.
Oh, it's so great. Thank you. Thank you. It's such a pleasure to have you on the show. And I hopefully we can find ways in the future to collaborate together.
That would be fantastic. And my best wishes to you and the show for 2026.
Yes, thank you so much. Thank you so much. And we'll talk soon.
We will. Okay.
Okay, bye-bye.
Bye-bye. Ka kite.